Really, this is, you made mention of the fact about the court decided that this was dismissed. And I couldn't get the gist of what did the court decide? What is the ramification of what they said?
So let's get into a little bit of civil procedure. The court case was filed claiming that the cup should be invalidated, okay? We defended the case, and when you have a statute of limitations defense, which is what we had, 60-day period,
Okay.
the way that you raise that, or one of the ways that you can raise that, is by making a motion to dismiss.
Because it's outside of the 60.
That's what I did.
Okay.
We had a hearing on that motion, and the court dismissed that claim under the 60-day rule. It's too late.
Okay.
That's what happened.
Okay. So I've got an understanding on this, and all the information that you have been given, you've got a lot of relevant information. However, it is, all of this is due to the year after the 60 days. And I do not believe that that we make any decisions in regards to something that the court has decided. So what I see is a case that you have to do whatever you have to do to go after an extension of 60 days through the court system with all the information that you've had and problems that you had and such. But that, what we're dealing with is the facts of what's, when we went through the step-by-step, each thing, and the county staff approved, and that's what you're after, to get each of these changed. When I look at them, there's nothing we can do. Your issue is the 60 days, and if it's extended, you have tons of information that could perhaps become relevant. So I don't think, a lot of the stuff that we've heard, it's interesting, but we can't do anything about it because of the 60-day rule. We have no ability to do anything about that.
I just wanted to make sure that you felt you was heard and
Yes, yeah.
the township felt they
I,
were.
I understand that, but I mean, I'm trying, that's why I keep asking the questions, and I'm trying to bring something across to you also.
Yep, so can I ask you a question, please?
Only to the board.
Okay, so I have a question regarding the fact of reading what the powers of the Board of Adjustments are. And reading those powers of the powers of the Board of Adjustments, I do not believe that just because a judge dismissed this case, it is applicable to the Board of Adjustments. I believe the Board of Adjustments has the understanding to do its own, there are two different things that happen. You guys are your own entity. So a judge ruled one thing that does not bind the Board of Adjustments to not adhere to the law as given.
And you saw that where?
Well, again, had I had more time, I would have, again, so this is where I feel very much that I was thrown on the bus on this one. I have evidence at home. I cannot give it to you because I was not told this would be happening.
Madam Chair, I'd like to continue. I just, when you say that we have this power.
Oh, I'm sorry, Ordinance 62. If you actually look at Ordinance 62 under Board of Adjustment, under 8 something, it in no way states that if a court case was given, you can't have that power to either wholly, partially, or change a permit. I do not believe that in that section it would state, or it does state, I do not believe. And again, I feel unprepared in this, which I don't like, but I have read the ordinance a few times. But I believe the powers of the Board of Adjustment, you are powerful. And Nick Caponero said at the hearing, he goes, your avenue for this is the Board of Adjustments. So I'm hearing two different things from the attorney, but if you look at ordinance 62, section 8, when it talks about the Board of Adjustments, your powers do not, are not limited to a 60-day appeal. That, it's limited in a court case possibly, but not here.
Well, when I'm looking at what we're dealing with, we have a Board of Adjustment determination. We have these items that are listed. I read that, and that's what we're dealing with. And that we have certain rights to do things. I don't necessarily agree with that. And being we have the attorney once again, do we have those kind of powers?
The power that you have in connection with this appeal,
The appeal, I read that, I know what we can
Yes.
do, but I can, the relevance is we can't all of a sudden just throw into the mix something about a septic system or something back from 2008 or anything. We're dealing with these items right here.
correct. And not only do you have the affirmative determinations that were made, you have the director expressly saying on page 1, just so everybody knows, I am not making determinations with respect to this null and void theory that we've heard so much about today.
Yeah.
It's almost as though the director foresaw
Yes,
that something like this
yes,
might happen.
and I'm seeing it. Yes. Okay, thank you.
So I'll back at a few notes. Yes, the director intentionally would not address that concern in my administrative appeal, in my complaint. He intentionally would not. And if you do know now, he has resigned. I can't say why, but that director's resigned right now. He resigned surprisingly on May 5th.